Season 8, Episode 3 of CI webinar series. I hope every one of you is staying home and doing well in this pandemic. The topic of discussion today is arbitration in oil, energy, and gas disputes, where our keynote speaker is ICC YAF representative of Africa, Middle East, and Turkey, Ms. Laura Karuri Alakija. Our today's program is hosted by the Center for International Alternative Dispute Resolution CIADR, where I, Nazifa Munyad Kadir, will be hosting the program. I am an Associate Counsel of CIADR and also the Director of Research and Training of YCI-ADR. I have completed my LLB honors from University of Dhaka and am currently pursuing my LLM from the same institution. Now, before we begin, let us introduce CIADR. CIADR is the first and only online dispute resolution center in Bangladesh at present, providing the most reliable and cost-efficient dispute resolution services since 2018. Within a span of only 2 years, CIADR has attained quite a reputation for its fast-rating dispute resolution tactics. Besides, CIADR has recently established 6 highly functional sectors, namely ADR News, ODR TV, Research Center for Conflict Resolution, ODR Institution, and Membership and Communication Department. These sectors are headed by the most enthusiastic and remarkable law students and young lawyers of Bangladesh, who signal their persistent passion to spearhead a new era of ODR development and expansion both for the CIADR and global ODR ecosystem. CIADR aspires to be uninterrupted provider of premium institutional aid as a tangible and independent venue to conduct the domestic and international ADR and ODR proceedings. As a part of this endeavor, CIADR webinar series is being a pioneer in creating an actionable community and ensuring solutions to combat the future economic crisis in the global community. In this webinar, our speaker, Ms. Laura Karuri Alakia, will talk to you through the concepts of arbitration in oil, energy, and gas dispute and the issues arising of it. Laura Alakija is managing partner and partner overseeing commercial transactions and commercial disputes, arbitration, and ADR at Primera Africa Legal. Laura's antecedents are as a transactions lawyer specializing in energy and natural resources, hospitality, and IT law before turning her attention to pre-dispute negotiations, dispute management advice, arbitration. As an ADR practitioner, Laura has led a number of administrative interventions before various regulatory bodies in Nigeria, acted in a number of mediations at the Lagos Multi-Door Courthouse, and in various capacities in both ad hoc and institutional arbitrations under the Lagos Court of Arbitration LCA Rules 2018, ICC Rules 2017, RCICAL Rules 2008, the Lagos Home Ownership Mortgage Scheme Arbitration Rules 2012, and Arbitration and Conciliation Act CAP 18, Laws of the Federation of Nigeria 2004, among others. Ms. Laura is an active member of the arbitration and ADR community, currently serving as ICC-YAF representative for Africa, Middle East, and Turkey. Laura is passionate about growing arbitration and ADR on the continent and particularly in her home country, Nigeria, where she believes the right approach to commercial dispute resolution is key to consolidating any efforts at growing and diversifying the economy. She is an annual supporter of the LCAYAN moot, where she sat as arbitrator in the last three competitions in Lagos, Nigeria, and was one of the organizers of the maiden edition of the Lagos Pre-Moot competition in February 2020. She is also an avid researcher and a frequent speaker at conferences. Laura Alikija received her legal education at University of Eos, Nigeria, where she completed her LLB, and she completed her LLM from University of Derby, United Kingdom. Dear viewers, so let us hear from our valued speaker, Ms. Laura Alikija.
Can you hear me?
Yes, madam, I can hear you.
Okay, thank you so much, Nazifa, for that kind introduction. And it's my pleasure to join everyone on the CIADR's webinar series this weekend. I am very excited to be speaking kind introduction, and it's my pleasure to join everyone on the CIADR's webinar series this weekend. Hello, can you hear me? I had a bit of an interruption, a bit of an echo on the line. Right. Go ahead.
Is it okay now?
Oh. Yes, it's okay now. There was a bit of an echo on the line, so that was why I had to stop for a bit. Yes, so I was saying that I'm very excited to be speaking on the subject of energy, oil, energy, and gas, and also the subject of arbitration, because those are two areas of law that are very dear to my heart. I've had quite a bit of experience working with energy transactions, and arbitration is a very recent phenomenon for me, something that I've
Laura, I think I can't hear you somehow. I'm so sorry.
Hello, can you hear me?
Yeah, now I can hear you. I'm sorry.
Okay, that's fine. Where did I lose you so that I can backtrack?
I think that was a fault from my end, but I guess the audience can hear you right now.
Okay. So, as I was saying, my topic is to speak on arbitration in the oil, energy, and gas industry, and I'm to focus on the MENA perspective. So I will go a little bit over what is obtainable in some parts of the Middle East and Northern Africa. But the nature of the energy industry is fairly the same around the world. So apart from the nuances of local legislation, the contracts and the issues around dispute resolution are pretty much the same. Energy security and the demands from different parts of the globe have made it such that the industry, even though it is international, it is one all over the world. So that makes my job a little less daunting. Otherwise, I would have had to gain some expertise on the local laws of quite a number of jurisdictions to be able to speak to this subject. So I'm going to go straight into the topic. You will see my outline over there. And I've tried to simplify it as much as possible so that everyone who is part of this seminar will be able to take something from the conversation. So I'll start with an introduction. I'll talk a little bit about the oil and gas landscape in the MENA region. Then I will talk about the different contracts and the entities that are involved in the oil and gas region before delving into arbitration in the sector and the different trends. What one can expect from dispute resolution in the oil and gas industry, especially around this time. So, by way of an introduction, the oil and gas sector in the MENA region uh, produces about half of the world's, it has about half of the world's oil and gas reserves. So it's a very important region as far as energy, as far as global energy is concerned, because whether we're looking at crude or we're looking at natural gas, the world's largest hydrocarbon reserves are in this part of the world. So the MENA region is central to the global energy balance. And this is in spite of the fact that we're believed to be approaching what is known as peak oil. Peak oil means that we're about to reach a place where we have tapped most of our oil reserves, and that volumes would start to decline. In spite of that, the MENA region still has a lot of oil and gas reserves, and is still pivotal to the global energy balance. Outside of where we are with oil, there's also the fact that the MENA region, we have a lot of oil and gas reserves, and it's still pivotal to. I'm sorry, the echo came through again, so I just waited a little bit. So I was saying that the MENA region is still pivotal to the future of energy because in spite of where we are with oil, gas is something that we have only discovered fairly recently, and a lot of it is untapped around the region. So the importance of the region cannot be overemphasized. And I'm going to go over a little bit of statistics to help us gain some perspective. So the Global Energy Institute forecasts that between 2012 and 2014, energy demand globally will rise by about half of what it is right now. And the way that demand is split between the developed world and the developing or emerging economies is the developed world, because largely the infrastructure gap has been covered, and energy, they've been able to meet energy demands in those parts of the world. Energy demand will rise by about 18%. But for the developing world, you'll see that energy demand will rise by about 71%. So our region is not only important in terms of production, it is also important in terms of consumption. Now, I'm going to go over a little bit more data, and I hope that this data will not be so confusing. But I'm still talking about the same forecast between 2012 and 2014. And in terms of demand, you will see that in the left-hand pane of my small chart, you will see that the demand for fossil fuels, and when I say fossil fuels, I'm referring to petroleum and gas, you will see that the demand will decline just a little bit, but we will still have significant rise in the use of those fuels to generate power and other forms of energy. This is just because of the shift that we've discussed in demand from the developing world to the developing world. This is why these numbers are the way they are. But if you look at the splits in demand, you will see that for the next 20 years at least, the demand for petroleum will still be the highest and in terms of sources of energy. So 30%, coal will be 20%, and gas will be 22%. But of those three, of course, gas is experiencing the highest rate of growth of about 60%, of about 70% in use actually, in comparison to the other sources of energy which we have been using for a significant period of time. So in general, the growth for use of these energy resources between now and 2040 will be by 38%. Now, if you look at renewable energy, which is where the world is sort of heading at the moment, even though it is still, a lot of it is in research stage. A lot of it is the this there's a lot of research going on trying to discover how to generate large volumes of renewable energy. So there will be some growth, but it's marginal. So between now and 2040, the projection is that renewable energy the demand for renewable energy will grow from 12% to 16%. So that's just about 4%. And use of nuclear energy will also just. What is interesting though about nuclear energy is that we will have nuclear capacity will grow between 40 by 87%. Don't ask me what we're going to do with all of that capacity, but for now, these are the. So that gives you a picture of where we are with resources around the world and what the projected use will be, and the sort of direction that our traditional oil, gas, and energy sector will be moving. So if I were to interpret these numbers, I would say that we will see a lot more gas to power for energy. I don't know as of yet how far, say for instance, electric engines will swap out petrol engines. So I cannot reasonably project how much of a decline there will be used in the use of petroleum itself. But for gas, I know that the growth in use of gas will largely be for gas to power and other domestic uses, of course. So that gives you a sense of where we are, and that also gives you a sense of what is going to be happening in our region, because like I mentioned in my introductory statement, we have large petroleum deposits and we have large gas deposits which are untapped. So in spite of peak oil, Middle East and Africa will be important to the global energy balance for a very long time. Now, just a little bit more statistics before I move away from here. So I selected a number of jurisdictions in the MENA region just to give us a clear picture of why this region is so important in that play for energy resources around the world. And if you look at the first column, you will see that Saudi Arabia has the largest oil reserves, which is about 17% of global oil reserves. Egypt has the largest gas reserves with about 90 trillion cubic feet of proven reserves. Libya has the largest oil reserves in Africa. Iran has 17.8% of global gas reserves, about 1,200 trillion cubic feet of gas. And you will see that the United Emirates, particularly Abu Dhabi, has huge gas reserves. So out of a total of about 97.8 billion barrels of oil, sorry, not gas, Abu Dhabi has 92 billion barrels. And you will see that Algeria has the second largest gas reserves on the continent. It has the largest gas reserves on the continent and the second largest gas reserves after Nigeria, oil reserves after Nigeria, and it's the 10th largest in the globe. And I'm going to quickly go over the data. So you will see that outside of the volumes of oil or gas, or oil and gas that each of these countries and the other African countries have, I didn't bring in countries like Tunisia or Bahrain, but there's, we have huge gas reserves all over the continent. You will see that these resources play a significant role in the economy of most of the countries in the MENA region, apart from Dubai, which seems to have the United Arab Emirates, but particularly Dubai, which seems to have a diversified economy. You will see that oil and gas exports account for a large percentage of exports and also significant chunks of the GDP across the countries. You'll see Saudi Arabia with 70% export earnings, Libya with 69% export earnings, Algeria with 85% export earnings, and varying GDP from 50% to 13 to 60% to 20% GDP from Saudi Arabia, Egypt, Libya, all the way to Algeria. Now, so that tells you that these resources, as important as they are to the world, they are also important to the countries that own these resources. And pretty much across all the countries that own natural resources, those resources are usually held by the government. So that's the same case along all around the Middle East and North Africa region. And you will see that even in terms of structure, the entities, the countries are structured pretty much alike in that regard. The regulatory framework is similar, not exactly the same, but it is similar. And you will see that for most of these countries, the national oil company regulates the industry, either just the national oil company or the national oil company together with a government agency, maybe a Ministry of Petroleum or Ministry of Natural Resources. Across the spectrum, you will see that Saudi Arabia has the Saudi Aramco. Egypt has the Ministry of Petroleum, but it also has 5 state-owned entities that perform different functions and regulate with different aspects of the oil and gas sector. You'll see that Libya has its National Oil Corporation. Iran has the National Iranian Oil Company. The UAE has ADNOC and the Supreme Petroleum Council. And Algeria has Sonatrach as the national oil companies that regulates the affairs of the sector within those countries. Now, in terms of arbitration, I would say that the region has come very far. Before now, resource control has meant largely over most of Africa that and the Middle East that because those resources reside in the central government, dispute resolution is usually left to the local courts. In some instances, because the agreements between the state governments and oil companies are what regulate and drive the relationship when it comes to exploration and production of petroleum or hydrocarbons, you find that at a party level, sometimes because of negotiation, the parties may then decide to take some of the disputes outside of the continent. So you have instances where it's either we go the route of the national courts or we go to the international courts. That depends a lot on negotiation among the parties. But the tides have started to turn quite slowly. Quite slowly, because if you look at some of the legislation that I have on my screen, you will see that we have some recent arbitration laws across the region, but some are. There is a transition in the oil and gas industry from the traditional national court. This has happened more in the developed world. The oil and gas industry has actually embraced arbitration for a very long time, but in the Middle East and Africa region, you find that the changes have happened a little less quickly, but nonetheless, they are, and countries are beginning to embrace this. So you will see in terms of legal framework that Saudi Arabia, for instance, has the Kingdom of Saudi Arabia Law of Arbitration of 2012, and it is largely based on the Armstrong Model Law, which has wide acceptance around the world in terms of arbitration. You see that Egypt has the Arbitration Law number 27 of 1994, which is also based on Armstrong Model Law. Libya is a slightly different story. Libya arbitration is regulated under Chapter 4 of the Libya Civil Procedure Code of 1954. That chapter contains the arbitration laws of Libya. And then the Petroleum Law of 1995 for Libya also has it has provisions for domestic arbitration in Libya. And then you have the law of the Chamber of Commerce 2004 and the investment law number 5 of 19, and different aspects of dispute resolution, particularly arbitration. In Libya, for Iran, you'll see that it has the Iranian law on international commercial arbitration. It's based on UNCITRAL model law. And you see that the Iranian Code of Civil Procedure 2007 regulates domestic arbitration in Iran. The UAE has very recent legislation of 2018, Federal Law number 6, and it is based on the UNCITRAL model law 2006. So in essence, in terms of putting together the framework and the infrastructure for alternative dispute resolution across the region, the different countries are taking steps to do so. And the idea is to improve or to make the region attractive to investors, because prior to use of arbitration as a mechanism for dispute resolution in the energy sector, one of the key challenges that investors had was, the system of dispute resolution and, governments generally being, generally not keeping to their side of the bargain. So some of those changes in the dispute resolution mechanism, which promotes trust and confidence for investors, have helped to sort of create a better relationship between investors and host countries. Not to say the least, investment treaties have also been useful in that regard, and a number of international conventions. For the region, you will see most of the countries are signatories to the New York Convention and ICSID. The New York Convention is on the enforcement of foreign arbitral awards. So wherever you do your arbitration, if the host state or the parties are from states that are members of the New York Convention, then it's easy for you to get enforcement of those awards. Outside of the regulatory framework and the international conventions that the states have adopted, you will see that there are also arbitral institutions that have been developed in each of those states. And the idea generally is to encourage investors to invest in those locations so that whenever you have disputes, there is a mechanism that you can rely on for resolution of those disputes. And I will not go over each of the arbitral institutions. That is a question that we can look at in our own time, but just to draw to our attention that arbitration has become so popular in the region, in particular the UAE and specifically Dubai has become a arbitration in the Middle East. Dubai, Egypt definitely have become a hub for arbitration in the Middle East, and we will see subsequently how arbitral institutions in those spaces are even taking further steps to localize investment disputes so that we provide a climate that covers investor concerns end to end, including the resolution of disputes. Right. So I'll proceed quickly to talk about some of the oil and gas parties and the kinds of contracts we can expect and the kinds of disputes that arise out of the sector. And I'm starting with the upstream sector. If you understand the way the oil and gas sector is structured, the upstream sector has to do with exploration, development, and production of hydrocarbons. So that sector is where you explore for your petroleum products and you develop them and produce them, so you are able to win oil and take it from the ground, or win gas and take it from the ground to the midstream sector, where you do all of the processing and purification before it goes to the downstream sector, which is where you have the distribution for consumption to the eventual end user. So that pretty much is how the oil and gas sector is structured. I have deliberately gone along those lines because, well, looking at my topic, I'm talking about energy and then I'm talking about oil and gas, and there are slight distinctions between the two. But um, from the perspective of energy, I thought that it would be easy to put that somewhere between the midstream and downstream sector, because whatever the energy sources are, if the source has anything to do with fossil fuels, then um, the the processes or the parties or the contracts are the same at the point when you are extracting the hydrocarbons for your power projects from the ground. So, in terms of the key players in that space would be your governments, your oil companies, whether it is the national companies or the national oil companies or the indigenous oil companies. Uh, Oil companies would be your big Goals, Total, EPP. I mean, the names have changed over the years, but those basic entities that have carried on oil and gas operations around the globe. And in the early years of exploration of oil and gas for most oil and gas producing countries, they've entered into agreements such as concessions or joint venture agreements or licensing agreements with oil companies for the exploration and production of oil and gas. And those agreements essentially have been what those agreements have regulated exploration and production of oil and gas in those sectors. Those are part of the regulatory framework. Outside of the law itself, your joint venture agreements or your joint operating agreements or your production sharing contracts form part of the regulation for that sector. It is in those contracts that you determine what role the national oil company plays, how it goes into partnership with the international oil company, and in recent times, the indigenous oil companies, which are now starting to come on board as players in the oil and gas industry, in the downstream, in the upstream sector of the oil and gas industry for most oil producing. So, like I explained, the sorts of contracts you have are your concessions. That is where the government gives a large area, which could be made of several fields, to one entity and concessions it for a long period of time, maybe like 50 years, and they can explore and develop and produce, win hydrocarbon resources from the ground and sell them. So the concession is an outright grant of rights over a defined area of land which has hydrocarbon resources under it, and the government's revenue in those circumstances would be your signing fees and royalties. So the oil company essentially would own, would have complete rights to the resources and pay signing fees and royalties to the government. And then so it's what early agreements that happened in that space. And then you have your licensing agreements, where in some jurisdictions, in Nigeria, for instance, you could get an oil prospecting license. Then when you find reasonable quantity, you oil development and production, then you get your oil mining license that gives you the right to win oil, win gas from the ground and produce it, and then sell it more or less uh, in international markets, actually. Um, for most oil countries, oil and gas producing countries in the region, we're still doing a lot of imports for refined products. So you have those arrangements. You have your production sharing agreements where the or less the contractor, they take all of the risk, they make all the investment, and then they prospect for oil. Once they find it and they win the crude out of, or the gas out of the ground, then they back out their cost, what is known as cost oil. So everything it costs them to prospect and to develop and to produce the oil, you take out your cost oil, and then you split your profit oil with the government. So that is, and as the name implies, it's a production sharing agreement or production sharing contracts, depending on the jurisdiction. The principle is for the contractor, in this case, the oil and gas company, to get a share of production for its efforts. And there are other arrangements, joint venture agreements, where the national oil company, for instance, goes into partnership with oil and gas companies, and they jointly explore and produce crude or gas from designated licensed areas. And in those sorts of arrangements, there could be different arrangements. It could be that the national oil company would fund its share, because it's a joint venture, would fund its share of the costs for exploration and production. Or sometimes the private entities will fund it and they will carry the government. It's called a carry arrangement. So you pay the government's share of their of expenditure for exploration and production. So every time there's a cash call to put some money into exploration and production, the private parties would pay the government's share, so that they are able to recover those sums from the government at a premium. And so that happens sometimes. Other times the government funds its share, and parties carry on. So those are the different kinds of agreements you have in the upstream sector. And those agreements regulate certain kinds of relationships. You will see my cursor over some of the relationships the agreements regulate. The reason I have highlighted the areas that those agreements regulate is because those are the areas where the disputes typically come from. And so once you understand what the agreements regulate, then it's easy to understand where the disputes are coming from, and to be able to alert one's mind to how to handle disputes in that space when they arise. So you will see that I have exploration and appraisal. Those are the early stages, when you're still trying to determine the reserves that are in the ground, in order to know whether it is viable to proceed to development and production. You have development and production. That's the stage after you've confirmed the reserves that are under the ground and determined that you want to go further to produce the crude. And I mean, these lists of agreements is not exhaustive. For instance, in your exploration and appraisal, sometimes you have what is called as seismic study agreement, and a number of other agreements that help you to determine how much crude you have. And other entities who sometimes may be external to the oil company, but whose primary job or whose primary business is carrying out tests and determining the gas reserves or the oil reserves that are in the ground. So for your development and production, you also have a number of contracts that would include your EPC, engineering, procurement, and construction contracts to construct the facilities that you will use to drill for oil, and a number of other contracts. And disputes can arise there between, for instance, the operator. So if the entities that are going into production are a joint venture, for instance, or they have a joint operating agreement, so they may not necessarily be a joint venture. They might be 3 or 4 different entities who have agreed to come together to explore and produce oil from a particular field. Usually, because of the cost of exploration and production, most entities, regardless of their size and their balance sheets, decide to spread the risk by going into exploration and production jointly. So when you have that kind of joint, operation, usually one entity is selected as the operator. So under your joint operating agreement, one entity is selected as the operator. So it acts on behalf of all the other entities to carry on the exploration and production. Usually doesn't get paid for that job, but all the parties put in their resources to fund and to support exploration and production. So under that arrangement, disputes can arise between the operating entity and the other joint venture partners. It can arise between the operating entity and contractors because the operating entity is responsible for operations. It has direct interface with contractors, with engineers, with suppliers, all of the entire ecosystem that is involved or that is used for exploration and production. So disputes can arise in that space between the operating entity and any of the other entities, either its joint venture partners or the entities that are providing services. So contractors, subcontractors, suppliers, you name it. It's a large ecosystem. So disputes can arise out of there. You have tax and royalties, so disputes can arise between the oil companies and the government as to taxes and royalties payable. The jury is still out as to whether or not tax should be something that comes under arbitration, whether tax should be subject to arbitration. But I will not go into that. There's ownership and transfer, which is very pivotal. Like I mentioned earlier, ownership of gas reserves, oil and gas is vested in the government of the host state. So that government is the one that grants licenses to private parties to explore in their states. And so sometimes there are disputes around ownership and transfer. There are disputes around what the government has transferred to the entities and what they can do with their license, the scope of application of their license, and questions around, for instance, persons who were residing or who owned the piece of land where you have now discovered oil, and government as the owner of the resources under the ground. Sometimes there can be disputes or conflicts between the government as the holder of resources that are under the ground and the individuals or corporations or communities that have surface rights who own the land on the surface. So any kind of dispute could arise in those circumstances. And that relationship is usually backed by a number of arrangements. So disputes could arise there. So those are other areas that you could find oil and gas disputes. There's also expropriation and stabilization situations where the government decides for overriding public interest to take over oil and gas assets. Disputes could arise there as to compensation, as to whether or not it was properly done, as to whether or not it was done in breach of a contract. I purposely put stabilization there because some contracts have stabilization clauses. So you will find that a government would have represented or given a warranty that it will not interfere with the license rights of the license holder. And when it does, then it will be in direct violation or contradiction of that clause. There's also treaty obligations. Sometimes oil and gas investments are covered under treaty obligations. So when two or more states have a bilateral investment treaty or a multilateral treaty among them, then investors from state parties to those treaties have some protection under that investment treaty. So when there is a violation of their rights or when there's government action that impacts their investment negatively, sometimes those disputes don't even fall under the underlying contract between the parties, but they fall under protected rights under investment agreements. And so we will see subsequently that the different types of arbitration that arise out of oil and gas disputes are of different natures depending on the underlying document and what rights is impacted. Finally, I've mentioned HSE and decommissioning because the environment is very important, and sometimes oil and gas activity means that there will be accidents like spills or explosions or fire outbreaks that will be harmful to the immediate environment, to the persons or living creatures that are residing in that habitat, and that could form the basis for dispute. So disputes could arise out of there. I use decommissioning very deliberately because the the history of oil and gas exploration is such that we haven't fully gotten there yet, especially for the MENA region. Decommissioning refers to a time when an oil asset has come to the end of its lifespan. When the asset comes to the end of its lifespan, there has to be responsible ways to decommission the asset. So if you've drilled holes on the ground, what do you need to do? If you have laid pipelines under the ground and they've come to the end of their lifespan, what do you do? Uh, if those things are not properly taken care of, they have a negative impact on the environment. Now, the reason I say the history of oil and gas is such that decommissioning, we're not quite there yet, is because a lot of oil and gas assets still have some life in them, especially in this region, and have not gotten to a point where you would start to decommission them or abandon them. Sometimes it's called abandonment. But disputes could arise out of that, especially around this time, where um, exploration and production, even the grant of licenses in the oil and gas sector are moving from the international oil companies who used to dominate that space to involve indigenous oil and gas companies. And you will find that sometimes the divestment of assets in that space happens from, say, an international oil company that has explored the asset for a while and then is now divesting same to a smaller or an indigenous company because maybe the reserves are depleted and it is not commercially viable for a company of that size to operate the asset. They divest it to a smaller company that doesn't mind the volumes and the margins that they make on that asset. Now, the challenge with that arrangement is that oftentimes parties skip the decommissioning. Nobody talks about what happens at the end of the lifespan of the asset. And sometimes decommissioning can be such a huge cost. It is actually a waste of the smaller companies' time and resources to buy that asset, to produce it to the end of its lifespan, only to invest a huge chunk of its revenue in decommissioning. So that is an interesting area for disputes. We're not quite there yet because the life of most of our oil and gas assets have not come to the end, but we're getting there. So those are areas to look out for in terms of disputes in the oil and gas space. Then I'm going to move to the midstream and downstream sector, and I put them together because I think one necessarily feeds into the other. If you remember what we discussed earlier, the midstream sector has to do with your processing, refining, transportation, before you get to your downstream sector, which has to do with distribution and consumption by end users of the oil and gas resources. Now, I've put in the energy sector on this level of the divide because for the sake of our conversation, I'm looking at energy in terms of power, electricity, power to drive engines. So whether it's transportation or industries or manufacturing, to drive heavy duty equipment, that's the way I'm looking at energy. So energy needs fall squarely in this space because usually if we're dealing with fossil fuels or hydrocarbon, then you're looking at energy that is converted from those fuels and used in those to provide power for those sectors. And I've mentioned that the sorts of parties that you find in this space are your transportation companies, your barge companies, haulage companies, processing companies, power plants, contractors, transmission and distribution companies, financial institutions. Financial institutions are everywhere actually because some of these contracts have financial aspects or financial arrangements. Remember that in the downstream sector, in the upstream sector, I mentioned carrying sometimes when the individual joint venture partners do not carry, say, for instance, the government entity, you bring in a financial institution to fund your exploration and production before you determine how to use your share of production to pay off those debts. So for that space, again, you have your EPC contract, because someone must construct and lay the pipelines for distribution, must construct and build the processing plants and the refineries and the uh, um, uh, liquefaction and regasification plants, your power plants, whatever it is that you're using your natural resources for in this space. EPC contracts are valuable because you use them to underpin the construction of those projects. And then you have your gas sale and purchasing agreements, your gas transportation agreements, your power purchase agreements, your operations and maintenance agreements, depending on who is building what and who is operating it and maintaining it. You have your, you also have your uh, uh, storage agreements, and then I threw in retail energy contracts there because for power, after you've entered into your gas supply agreement and you've taken your gas and entered into a gas transportation agreement for someone to deliver the gas to your plant, and you've produced your power, and you've produced your power, then on the back of power purchase agreements, a distribution company takes that power from you. That distribution company then enters into other agreements with the end users of power, whether they're industries or factories or entire cities or neighborhoods that they supply power to. So I've sort of put in documents or contracts to cover the entire chain down to the user. So you have your fixed rate or your fixed volume contracts, your declining rate contracts, your blended rate contracts. These just have to do with pricing, really, how you get to the last mile of your energy or your power chain, and the contract that regulates the relationship between the distribution company and the end users, and what kind of payment plan underpins it. Payment is key in that aspect, because the way the power sector in particular works is that from the moment you decide to buy gas for a power project, your gas supplier needs to be able to to have a clear line of sight to your revenue down to the end user. So what tends to happen is, for a power project, you cannot go into a gas supply agreement unless you have gone down the line and done your power purchase agreement at the very least. And so for the power producing entity, when you do your power purchase agreement with your end users, sometimes you look at the end users as well. Sorry, maybe the distributors this time. You look at them as well and see who they are on-selling to, just to confirm that the revenues from the end users will come back to your power distributor, who then will take that revenue and come back to you to pay for the power that you've produced, and then you need to go back to your gas supplier and pay for the gas. Usually gas supply agreements are long term. It's 20, 25 years. So you want to be able to continue to pay for contracted gas volumes year in, year out. So all the parties need to look all the way down in the gas, in the power chain. You have to align the interests of the end user, the distributor, the power company, and the gas producing and supplying company. You need to align their interests back to back. So one entity cannot have liabilities on one end which are at variance with liabilities at the other end. Otherwise, that is an immediate recipe for dispute. So disputes can come up along that chain in that sort of fashion, depending on who along the chain is unable to meet their financial commitments. And so the contracts we've talked about regulates aspects of the sector that have to do with storage and processing, liquefaction and gasification. This essentially, liquefaction and gasification Regasification has to do with taking gas and compressing it, turning it into liquids, into very small molecules, so that where you do not have pipelines, you can transport it by huge cylinders that take huge volumes, and then when you get to your destination, you regasify it before use. You have your operation and maintenance is also affected, is regulated by these agreements. Transmission and distribution for power is regulated by these agreements. And then you have your gas or your power purchase agreements. You have your storage and transportation agreements, whether it is for oil, for gas, or for gas, and a host of other services. So in that sort of way, I've tried to take an overview of who the players are and the sorts of contracts that you will find in that space in order to give us a clear view of the disputes. Just a moment. Okay, just to give us a sense of the sorts of disputes that we can expect to have in that space. So, having said everything that we've said, when it comes to arbitration, the relationships or the obligations between parties in arbitration would usually be derived either from a treaty or from a commercial contract. So it could be, like I explained earlier, that rights under a treaty between state parties have been violated, or direct contracts between parties have been breached. The nature of the contracts, the nature of the obligations, the nature of the breach will determine what kind of arbitration you'd be going into. So the first layer or the first separation we're going to make when it comes to arbitration in the oil and gas industry is the separation between what is known as commercial arbitration and investment arbitration. Commercial arbitration would mostly have to do with contracts between parties where there's been a violation of the contracts. Investment arbitration, of course, has to do with situations where a right that is protected by an investment treaty is violated. In that instance, then you know that your dispute is going to investment arbitration as opposed to commercial arbitration. The other nuance is that sometimes you have what is called an ad hoc arbitration or an institutional arbitration. Ad hoc arbitrations where the parties they select their arbitrator, and the arbitration is not administered by an institution. So the parties determine the selection procedure. When they get together, they determine the rules. Where you have the institutional arbitration, usually the institution will have preset rules which parties can then pick from and can, by their agreement, decide to adopt wholly or with some variations to guide the arbitrator as to how to conduct the arbitration while the arbitral institution administers the arbitration. Okay. So just a few differences in the forms of dispute resolution we've discussed. That is investment arbitration and commercial arbitration. And you will see that commercial arbitration, like I mentioned, has to do with contractual obligations. Relevant treaty usually is the New York Convention, because this doesn't have anything to do with investment disputes. So more often than not, the relevant treaty for most commercial arbitration would be the New York Convention, meaning that you can enforce your award anywhere in any contracting state of the New York Convention. Not all the rules for commercial arbitration, not all the rules for the institutions that administer commercial arbitration provide for confidentiality, but you will find that most commercial arbitrations are confidential. This is why business parties enjoy using them, because you can keep unsavory information out of the public domain, out of the public sphere, while you seek to resolve your commercial disputes. And you have a good number of commercial disputes happening on an ad hoc basis, where parties just determine that, it's more flexible, it's more affordable, I'm going to go with a particular arbitrator or particular arbitrators, which we will choose in a particular or appoint in a particular manner, as opposed to going with the institutional, which is a bit more structured, but costs oftentimes, I mean, it's not always the case, oftentimes costs a bit more. So those are the sorts of features you see with commercial arbitration. For investment arbitration, the disputes fall within the framework of a bilateral or a multilateral investment treaty. And I mean, there are different kinds of treaties that impact arbitration. And there are different kind of treaties that impact arbitration in the investment arbitration space. And you will see there on my list that I've mentioned a few: ICSID, NAFTA, generally BITs, and the New York Convention for enforcement purposes. Fundamental instruments that regulate investment arbitration are usually silent on confidentiality. Some treaties, I mean, provide specifically for confidentiality. They provide for arbitration and provide for confidentiality, but you will find that there are times when they're silent. And because of the nature of investment arbitration, because public interests are involved, you find that it tends to be more public because usually host states are concerned. I mean, host states are parties, and citizens citizens of those host states are interested in the outcome because it has national implications for the host state. So you will find that investment arbitrations are a lot less private and confidential, and so there's a lot of precedential value there. It means that it's possible to see what happened in one investment arbitration for the purpose of making adjustments either to your treaties if you're negotiating treaty obligations, or for the purpose of guiding governments in their future actions so as not to violate existing treaty obligations. And you can have ad hoc investment arbitrations as well as institutional. But with investment arbitration, the sheer size, volume of documents, and complexity of transactions, you find more often than not, investment arbitration is institutional as opposed to ad hoc. Right, so I'm going to talk you quickly through the sorts of disputes we have in the oil, energy, and gas space. We've talked about how the arbitration, by virtue of the relationships and the underlying documents, could be commercial or investment. We've also talked about how, by the choice of the parties, by their arbitration agreement or the instruments that provides for their arbitration, could then have an ad hoc arbitration or an institutional arbitration. Now, what we're going to look at now is the sorts of parties that you can have, the types of arbitration that you can have in the oil, energy, and gas space. And the first class of arbitrations is your, oh, just a moment. I think this presentation is missing a bit of information. Okay, which I can fill in by just mentioning. Okay, so like I said, the first set of the first kind of arbitration you can have in this space is a state-by-state arbitration. This has to do with things like boundary disputes concerning oil and gas fields that straddle international borders, or disputes arising out of interstate agreements like export contracts. And the example I've provided there is written as Israel versus Egypt, but the agreement is actually the Israeli Electric Corporation versus the Arab Republic of Egypt. And this particular dispute has to do with gas supply agreements. Yes, Egypt was to export gas to Israel and had, in the first few years of the contract, met their contractual obligations, but then there was some vandalism on the pipelines, and that impacted their contractual obligations. They were not able to meet up with those obligations, and so Egypt sought to terminate that gas supply agreement, which led to a dispute between the parties. So you see, in this arrangement, you have state versus state disputes. Subsequently, you can have a company versus state dispute, where a company that is an investor in another state could take the state to arbitration because of the violation, for instance, of a treaty right. And one of the examples, well, there are a number of cases that I've listed there as examples of where a corporation takes a state entity to court. One of them is Union Fenosa versus the Arab Republic of Egypt. Again, this had to do with gas supply. The parties signed a sale and purchase agreement, and the state entity did not meet up to their side of the contract because they had domestic supply, should I say, obligations, which they prioritized over this contractual obligation. And depending on the country, there are countries that impose domestic supply obligations on all their gas producers. You need to meet a certain quota of supply of gas to the domestic markets before you can supply, before you can meet your other contractual obligations. So in this instance, Egypt prioritized their domestic supply to the domestic market over their contractual obligations, and Union Fenosa Gas took Egypt to arbitration because they felt that their rights of fair treatment under the bilateral investment treaty between the state parties was violated, that Egypt had treated them unfairly, and they got an award in their favor, which confirmed that. And then other times you can have your company versus company disputes, so between two entities, like I explained earlier, the example I gave with the joint operating entity having disputes with the other joint venture partners or contractors that are working on the project. It could be anybody, the EPC contractor, a supplier, or any other party, depending on what the issues are. You could have disputes arising out of that. And the final category will be your individual versus company disputes, where an individual could take a company to arbitration. Usually these fall under HSC, that's health, safety, and environment, where an individual suffers irreparable damage and is not sufficiently compensated. Then you will find instances where, because of that injury, the individual comes with a claim against the company. So those are the kinds of disputes that you can have under the oil, energy, and gas sector as far as arbitration is concerned. So having discussed the kinds of disputes that we can have in the oil, energy, and gas industries, the last part of the conversation we're going to have is what the trends are. What kind of disputes can we expect to see in the future? Just to prepare, just to prepare our minds as to the sorts of changes we expect to see in the MENA region and what that means for arbitration and ADR practitioners. And I did mention earlier a little bit about increased localization of investor-state disputes. Like I indicated earlier, ICSID arbitration is probably the more popular arbitration for investor-state disputes. And more jurisdictions in the MENA region are starting to localize investor-state disputes. And I've given examples. Egypt's model concession agreement provides for dispute resolution in the courts in Egypt or arbitration in Egypt under the Corsica rules. That's the Cairo Regional Center for International Commercial Arbitration. Jordan's model production sharing agreement provides for arbitration seated in Jordan. Now, if you remember our cross-section of the laws in the different jurisdictions within the MENA region that regulates international arbitration, you recall that a lot of them were based on the UNCITRAL model law. So more and more countries are adapting their arbitration laws to be based on the UNCITRAL model law. And if their legislation is dated and doesn't include provisions from the 2006 UNCITRAL model law, then you see that states are beginning to update just to make that jurisdiction more arbitration friendly, to include provisions that have evolved over time and which make arbitration much more attractive for investors. And different countries are also putting up structures that make the jurisdiction more arbitration friendly. Places like Dubai have free zone areas which operate the common law system as opposed to the general civil law, cross of civil law and Islamic law that operates in around the rest of the country. For most jurisdictions around the region, courts are becoming more arbitration friendly. There's less court interference. Arbitral institutions in the region are being strengthened such that they are able to cater to these investment disputes. So that's that's the sort of shift that is going on. So we can expect the trends going forward to be increased localization of investor states disputes within the MENA region. There will be COVID-19 related disputes, no doubt, because apart from the tanking of oil prices, there's interruption of a lot of contracts. As the world starts to go back to normal, some of those disputes are going to come out of the woodworks. So one can expect disputes in those areas. There will be climate change related disputes as the world tries to move from to greener forms of energy, like we discussed, as the world experiences a decline in some fossil fuels, as we see less and less reliance on petroleum and coal, for instance, and a gravitation towards gas and other forms of renewable energy. There will be restrictions, there will be regulations that will throw up a number of disputes. So one can expect to see that. And then the final class of disputes one can expect to see going forward is a new generation of disputes in the public international law space. This essentially is just history repeat. I mean, before, in the early days of oil exploration and production, a lot of oil and gas disputes, because of their multinational or transnational nature and the fact that it involved parties from different parts of the world, those disputes were were resolved in the public international law space. Until that sector began to be more regulated by the national entities, and until arbitration came into that space and as an alternative mechanism for dispute resolution. And in spite of that, we still had a lot of public international law in the resolution of disputes in the petroleum industry. Now, with the discovery of larger reserves of gas in the MENA region, I expect that disputes will arise out of those, and that this generation of disputes will have to deal with in that space until we understand, until different gas producing countries begin to regulate exploration and production, including transportation, actually, and the consumption of gas uh, in from a more national perspective. So those essentially are my views as to what we can generally expect to see in the oil and gas dispute space. This, I believe, should bring me to the end of this presentation. I'll be happy to take questions or comments now, but thank
Um,
you for listening.
Thank you, Laura. That was a very insightful presentation. So I had a few queries. Please, I'm not an expert on this, so some of these questions might seem very silly. Please use your discretion in answering my questions.
That's fine.
So, uh, okay. So basically, well, in your opinion, do you think that if a state and another investor has an arbitration agreement, do you think that it exhausts the
I
power
need
or
to,
jurisdiction of the local
okay.
court?
Basically,
Well,
I'm
in
sorry.
your opinion, do
Okay.
you think that if okay, yeah, I guess someone has to another
There's a
investor.
bit of an echo, so you may need to repeat the question, please.
Okay, so
Yeah.
if a state and
Mm-hmm.
another investor have an arbitration agreement. So does that
Yes.
mean they cannot go to the local court? Does that absolutely ban them from going to the local, ban the jurisdiction of the local court?
Right. Well, it depends on what is in the contract. Usually, the disputes between a state party and an investor arise out of investment treaties. And investment treaties make provision for dispute resolution. And depending on how the treaty is drafted, there are some treaties that provide that parties have to exhaust local remedies before they go to arbitration. So if the treaty says you have to exhaust local remedies, it means you have to go to the courts. I've seen treaties where maybe they reserve some issues for resolution by the local courts. So things that the host state feels are within their purview, their rights to regulate. It's called the rights to regulate in investment treaties. So the things that the host state has a right to regulate are reserved for the local courts. Those do not go to arbitration. Some treaties provide for those. And then other treaties just provide that, all your disputes have to go to arbitration. Maybe sometimes with an initial provision for negotiations or mediation before you go to arbitration. So largely the investment agreement determines whether or not you can use the local courts.
Okay, so I have another question. I'm very sorry if this question seemed very silly, but
That's
okay.
okay.
So basically, we have seen the interpretation of clauses have been differently interpreted in similar contexts. For example, in Libyan oil nationalization cases, we have seen that the same clause has been interpreted in three different ways. So, what are your comments in these cases? In such cases?
In cases where the same clause appears to have been interpreted differently.
Yeah.
Okay, well, it could be any number of issues. Sometimes it could be the specific circumstances of the case. The circumstances of the case could be such that even though you're applying the same provision, it has different implications for the parties. Other times, dispute resolution with the best will on earth is conducted by human beings, and human beings belong to different schools of thought. They understand and appreciate issues differently. And sometimes you find that a single provision, especially if it has a tendency to lend itself to ambiguity, will be interpreted by different arbitrators or different courts in different ways. So usually those are some of the challenges that disputants face. Uh, with with those are, the small windows of uncertainty that a disputant could face when it comes to interpretation of laws.
Another question, which is regarding, we have often seen that the when a government changes, we have seen that suddenly they do not always um, respect the clauses of the investors, and we have seen the provision of stability clauses as well. So
Yes,
the
yes,
scope. There has been certain questions regarding the scope of the stabilization clauses, which you have even spoken in your speeches as well. So,
yes.
can you like elaborate this scope of stabilization clauses as well? Basically, the recent development is economic equilibrium. So, how far do you think this economic equilibrium is working out? And how far is the stabilization clauses and freezing clauses working out?
Okay. Stabilization clauses, um, they generally tend to have, if I may say, one purpose: to ensure that uh, the investor does not suffer adversely due to government action. So, on the one hand, the stabilization clause is usually a warranty that the government gives to the investor to say that I will not take any actions that will negatively impact on your rights. So, whether it is legislative, regulatory action by the government, I will not take any of those actions to modify the legal situation of the investor. And where the government does take that action, then the expectation is that there will be certain steps you will take to make the investor whole. Um, I believe that is where the business equilibrium comes in, so that in the event that the government does have to take that action, the investor is not left holding the short end of the stick, but government takes steps to adequately compensate you. And you will see that investment treaties usually try to include detailed provisions for compensation in the event of expropriation. So the treaty would probably state outright that the government will not expropriate any investment, and then they will give exceptions for national interests, overriding public interest, national security, those kinds of reasons. But under those circumstances, then the treaty will go ahead to provide detailed provisions of what happens in the event that the government does have to appropriate your business. How do they compensate you? How do they arrive at value? In what currency do they pay you? Those details are usually contained, uh, at least in the modern investment agreements. You will see them there so that the investor can have some comfort.
Basically, the stabilization clause cannot absolutely ban a government's right to expropriate.
No, it's not 100% bar on government's rights, but it just provides that if the government does uh, um, expropriate or back into your rights, then they must compensate you, and the compensation must be fair compensation.
Okay. This would be the last question, basically.
That's all right.
So we have seen that basically, if if a foreign party wins the cases in the international tribunal, they have bad experience in in enforcing the said award in the local jurisdiction. So,
Yes.
what would your advices of? Basically, this is bad for the host country as well, since that would be discouraging the foreign investors in that country. So, what would your advices for such for efficiently running these kinds of issues?
Well, it's an interesting question. And quite frankly, I'm searching my mind to see the best way to answer it. It's unfortunate that governments are not the best candidates for complying with arbitral awards, and sometimes the solution starts from as early as the documentation. When parties are going into contracts, oftentimes, they're excited about the new relationship. They don't want to be difficult. They just want to sign the contract and move on. And if you're a legal practitioner and your job is to draft those contracts, usually even your client doesn't like you because you seem to be wasting their time and they're trying to move on with this transaction. But the beauty of documentation is that sometimes you can build in safeguards that will help you in the days of dispute. So if you don't have a solution in your contract, then when you go to the dispute resolution phase, you might encounter some challenges. Be that as it may, for those kinds of disputes, it helps to employ some creativity in resolving the disputes. I think that investment disputes are one of the areas where you cannot just throw the law at the dispute, because having thrown the law at it and secured an award, the question you now ask yourself is, how do I enforce? So if you haven't looked ahead and looked into the future to see what the possibility of enforcement is before you even start your arbitration, then it's possible to run into some of those issues. And I mean, there could be any number of reasons why governments default, and there could be any number of challenges in recovering um, uh, what do you call it? In recovering whatever has been rightly awarded to you. And parties can use all sorts of mechanisms where you've left your contracting phase and you've come to the dispute. Sometimes, if it looks like the counterparty is unlikely to meet their obligation, some kind of security, you can apply to the tribunal for some kind of security wherein they pay in money to cover what the outcome of the dispute is likely to be. So if money is awarded to you and the counterparty has paid in some security before the award, then it's easy for you to get your money and walk away. Otherwise, you've got to um, you've got to find creative ways to levy execution for when your award comes to you. And I find that third party funders are very creative, possibly because they have commercial they have, that's the life of their business, is what they do. They have a creative way of levying execution and recovering whatever has been awarded to them. And I think that practitioners, especially counsel and investment disputes, would do well to you know employ some of those creative ways of trying to secure the proceeds of your award.
Basically, the solution should come at the beginning of the whole treaty, at the documentation period. Okay.
That's
Uh,
a good place to start. Yeah.
okay. So basically, this was a very interesting I had a very wonderful time with you, Laura. So I guess
Thank you very much.
we could end here. Thank you. Thanks to the
Right. Thank you
audiences.
so much, Nazifa.
Yeah, we
Thank
can.
you for the opportunity.
Thank you to CIDR for hosting this kind of presentation and this webinar. So I think we can end it here.
Yes,
Thank you,
thank
Laura.
you so much. Enjoy the rest of your day.